Hi class, this is Mr. Tan again, and we are on the beautiful slopes of Box Hill. The top of Box Hill here, if you can see on this 360-degree camera, you can see all the landscape around you. You see that bird over there gliding as well. Beautiful, absolutely beautiful here. And on a beautiful sunny day with clear skies, you should be able to see all the way from here all the way down to the coast of Brighton. So today we are looking at P2 in business law, and P2 says explain the role of government in lawmaking. So explain the role of government in lawmaking and how statutory and common law is applied in the courts. So explain the role of government in lawmaking and how statutory and common law is actually applied in the courts. So again, the first thing we do is to break the question down, and firstly we identify the key word or words here. The key word here is to explain, and to explain, as we've identified before, means to go into more detail. Now, so we have to explain the role of government in lawmaking. So when we're talking about the government making laws, we're looking at legislation, the legislation that they implement. And when we're looking at the legislation, as we've looked in P1, we're looking at the different types of bills that the government can put forward. The different types of bills which we've identified before, which you would explain briefly again, which would consist of the public bills, bills put forward by front bench MPs, private members' bills, bills put forward by other MPs in the House, backbenchers from the House of Commons and MPs from the House of Lords. The private bills, these include bills which are where organisations and special groups put pressure on MPs to put forward these bills. And hybrid bills, it's a combination of bills combined together. So when we look at these different bills, these bills have to go through a certain process in the House of Commons and the House of Lords. In the main, the majority of the bills can start in either house, either in the House of Lords or in the House of Commons. But there are certain bills, when it comes down to finances and defence, which must start in the House of Commons. So what is the process that they must go through? Well, the process, which will be the same in both houses, will consist of firstly a first reading. A first reading will be a brief proposal outlining the title of the bill and the details, and then it is published. And then after a first reading, later there will be a second reading, and the second reading will basically detail more details of the bill. MPs will have a chance to discuss and debate it, and then MPs will have the opportunity to vote on the bill to see if it gets moved forward to the next stage. And then the next stage is a committee stage, and at the committee stage you basically it's debated, and industry experts come in, give their views, and here again interest groups will give their bills, amendments will be made, and then once MPs are happy, then it will move forward to the next stage, which will be the report stage. In the report stage again, MPs will have a further opportunity to make any amendments, and then finally there will be a third reading. And in the third reading, again, MPs will have an opportunity to make further adjustments and amendments to the bill. After it's gone through the third reading, it then goes into the other house. So if it started off in the House of Commons, it will then go to the House of Lords. And it will go through the same process. It will go through a first reading, a second reading, a committee stage, a report stage, and then a third reading. After the third reading, and if it went through the House of Lords, it would then go back to the House of Commons, allowing the House of Commons to make any amendments that they would like to make. And after that, it goes for the approval of the Queen, for the royal assent. Then once the Queen has signed and assented to this, then it becomes legislation and law. So that is the process, and that's what you need to explain. And you need to explain, firstly, again mentioned the different types of bills: a public bill, a private member's bill, a private bill, and a hybrid bill. And then talk about the process, and you need to go into a little bit more detail in the process. The process being a first reading, a second reading, committee stage, report stage, third reading, and then going to the other house, back to the first house which it came from for any further amendments, and then to the Queen for a royal assent for her approval. Then it becomes law. So you need to explain that, and if you need any more information, I have put it down on the classroom which I've invited you into, which is at classroom.google.com. So if you see the links there, those links give you additional information and where to get more information. But please make sure when you go in those links you reference where you get the information from and read it and put it in your own words. So that's the first half of the question: explain the role of government in lawmaking. And then the second part of the question says, and how statutory and common law is applied in the justice courts. So before we give an example of statutory and common law, we must first explain the justice courts. So again, I've given you further links on justice courts and how it's split in the UK. So in the UK, England and Wales, we can see that you have, on criminal matters, you have the Magistrate's Court, and the Magistrate's Court deals with certain offences. For it could include offences like motoring crimes, minor criminal damage, drinking disorderly, drug offences, burglary. But any more serious type crimes, then the Magistrate's Court would normally push those cases on to the Crown Court. Now, in the Magistrate's Court, they can give a prison sentence of up to 6 months, and if it's more than 2 offences, then up to 12 months imprisonment. They have other options as well, other options including community service, fines of up to £5,000, and so community sentence, on probation. So these are the other type of offences that a magistrate's court can give. So in one way, it can be quite good to go to a magistrate's court, because you know the maximum sentence that they can give you for any specific crime, either 6 months for one offence or 12 months for 2. Now, there are 2 types of judges in a magistrate's court. One is a justice of the peace, and 2 is a district judge. Now, a justice of the peace is not really qualified and doesn't get paid to do that job and role, whereas a district judge will. A district judge will have the qualifications, would have studied for it, and will be paid to do that role, and will have generally more experience. So ideally, if you wanted to be sentenced from a magistrate's court, the difference between a magistrate's court and a Crown Court is that a magistrate's court doesn't have a jury, whereas a Crown Court does have a jury. So where you can be found guilty or not guilty, and can be given in a Crown Court the maximum sentence. So it's really deciding where you wanted to take your risk, and in the Magistrate's Court or Crown Court. But sometimes you don't have any choice, because the Magistrate's Court can pass you on to the Crown Court, depending upon whether it's a district judge or justice of the peace, depending upon who is actually dealing with your case. And then in the next court above is the High Court, and then after the High Court is followed by the Court of Appeal, and then at the top is the Supreme Court. And then to deal with civil matters, we are really looking at tribunals to do with family matters, to do with refugees, to deal with child support and pensions and immigration, can be seen in tribunals. And then we have the county court. County court today is anything really dealing with a civil matter of no more than £30,000. And in a county court, there will be two types of judges: circuit judges and district judges. Circuit judges will deal with those cases anything from 15,000 to 30,000, and district judges anything less than £15,000. And then you have the next court again above the county court, which is the High Court, followed by the Court of Appeal, and then followed by the Supreme Court. Now, in the High Court itself, you have various sections in the High Court. The High Court includes the family division, so you could get issues from the tribunals, and it could go, if it went to the High Court, it would go to the family division in the High Court. You could have the appeals from the Magistrate's Court. So if you wanted to appeal from a Magistrate's Court from your decision, then you could actually appeal it, and it would go to the appeals section in the High Court. Now, bear in mind this: once you appeal it, if you appeal it and you are still found guilty, then your sentence starts from the date from which you were found guilty in the High Court. So if you had waited a year in prison and you had a year to be sentenced to serve, then you would serve 2 years, because the year that you had previously had waited in prison to wait for your trial to come up, and then if you were found guilty, then that year if you were found guilty.